Please be seated. Veuillez vous asseoir.
Your Honor, for the record, we are in open session.
Thank you very much. The Chamber wishes to revisit the matter of proposals, the protocol for proposals for the public redacted version of the transcript of testimonies in private session. In the morning, we indicated that the prosecution, for purposes of this witness, would have to propose redactions to be done the following day. And when Mr. KenyaMOJA made his submissions, he requested that the matter not be left to the discretion of the prosecution alone. In light of that, the Chamber considers that it will be appropriate in the normal course to follow the normal course of resolving matters such as this. It will be appropriate then for the calling party to make the proposal and then communicate it to opposing parties for their reaction, and the Chamber to make a ruling thereafter. So in this case, we've indicated that the prosecution is to notify or make the proposal within 24 hours following the edited version of the confidential transcript having been notified. The question now is, how long would it take, should we take, for the opposing party, the defense in this case, to communicate their reaction as to whether or not they agree with the prosecutor's proposal? If we can take quick 2-minute submissions on that. KenyaMOJA.
Within a day, Mr. President, we should be able to have responded on our part.
Another 24 hours?
Yes, Mr. President.
Mr. Khan.
Your Honour, if the prosecution, we of course want, we're going to be consistent about this, these proceedings to be in the public as far as possible. If the prosecution, for example, gave us the redacted version in the morning, by lunchtime, we would endeavour to get back to the prosecution, and so that hopefully it could be released, with the courts. Indeed.
Do we have any difficulty with that proposal?
Not at all, Your Honour. If I may, however, just seek one clarification. The time period of 24 hours, would that include the weekend or exclude the weekend? So if we're testifying for Friday's session, would Monday morning be fine? Or would it be then Saturday morning?
Your Honour, we'd ask Saturday. We're happy to do that. And perhaps, Your Honour, it's a matter for the court. We're not trying to usurp any functions, but it may be that the court may agree that if both parties are in agreement, then the prosecution can be authorised to, or through the usual manner, I suppose, that this can just be put into the public domain. Maybe the bench only needs to be troubled in the event that there's a disagreement between us. But, Your Honours, whatever the bench decides, we're happy with. But I think regarding the question, if it's a Friday, they can give us it, on end of Friday, or they can give us it Saturday morning, and we'll respond on Saturday. And then if there is a disagreement, of course, the bench can look at it first thing on Monday. If there's not, it can be posted, without delay.
Mr. KenyaMOJA, I notice a difference between your position and that of Mr. Khan. You said you would need another 24 hours, but Mr. Khan has a shorter reaction time.
We could make ours 12 hours, Mr. President. We are on legal aid ourselves, so we have limited resources. But apart from that, I wish to say, on our part, we would like the time within which the prosecution is to react to apply regardless of weekends and regardless of holidays. We would really like that to happen regardless of that. And probably to hasten the reductions. On our part, we are prepared to attempt. Should I slow down, Mr. President? I'm obliged. On our part, we are prepared to attempt an agreement with the prosecution on the perimeters of the reduction, so that they do not need, so that there is a criteria for determination, and we do not mind the criteria that was applied in the reduction of the statements that were provided for us.
Prosecutor, about on the question of the weekend and holiday.
Your Honours, I'm looking at the calculation of time limits in Regulation 33 of the Regulations of the Court, which reads as follows. For the purposes of any proceedings before this Court, time shall be calculated as follows. Days shall be understood as calendar days. Days of notification of a document, decision, or orders shall not be counted as part of the time limit. Whether day of notification is a Friday or the day before an official holiday of the Court, time limit shall not begin to run until the next working day of the Court. Now, this is dealing with filings and not necessarily the sort of matters which the Chamber has before it. But, of course, the prosecution can and does work over the weekend. But my submission is it should not be part of the ordinary duties that the prosecution is required to do, that it should have to do it every weekend. We are talking about a public redacted version here. It doesn't affect my learned friends' preparations in any way. And my submission is that if the matter, when we're talking about a 5-day period, that's one thing to include a weekend. But when you're talking about a 24-hour period, Your Honours, and we receive the edited transcript normally at about 5:20 or 5:30 on a Friday afternoon, that there should be no reason why that cannot be delivered on Monday morning.
Can I just say that earlier I had suggested that whether it's an army or whether it's a hive of activity, certainly the Assembly of State Parties have given sufficient budget to the prosecution that there's many more people in the engine of that office than are present in this courtroom, and perhaps one of them on a Friday when we finish at 4 o'clock. We finish at 4 o'clock. During the day, they can follow the transcript and decide which bits needed to be edited out. And then it's a very simple job. We have software and you redact it out. You don't need to leave it all to the last moment. Somebody can follow proceedings. Your Honour, it's not only a question of prejudice to us. Of course, we're following the full discussions and the full evidence. But there is, of course, not only public interest by dint of the client's occupation as Deputy Head of State. We also have this very important matter that we want as much evidence as possible to be heard, so that people that know the truth may be able to come forward and contact the defence before evidence is completed, that may allow us to put questions or put information that may assist the bench properly determine whether or not witnesses are telling the truth in whole or in part, or whether or not they're not telling the truth. And, Your Honour, the publicity of proceedings is directly linked to the ability of the defence to test the evidence, and that's the only matter that we raise, and that's why we do have an interest in that getting into the public domain as soon as possible. For example, if the prosecution did this by the end of Friday, for example, it may be, we don't know, how this will be broadcast, how that will be relayed. If the bench gives a summary, that may of course help. But, Your Honours, if we have to cross-examine on a Monday or a Tuesday, from experience we all know from public proceedings, people come up and say, oh, I know about this person wasn't there, they were here. And that is directly relevant to us in our attempts at cross-examination, so that Your Honours may uncover the truth rather than a simple narrative, sometimes that may be truthful, sometimes which may be coached, and sometimes which may be a mix of both.
Mr. Ken, I think we've got your point. The rule about public holidays and weekends are usually by convention in other places. Normally, when you have a short period of time, weekends and public holidays do not count. I mean, it's not only in this court that we have that. And the thing then is that weekends and public holidays have the effect of shrinking time. So it loops over to the next business day.
Your Honour, indeed,
It
Regulation
doesn't create
33
prejudice
is...
in that sense, does it?
Well, Your Honour, as my learned friend indicated, Regulation 33 deals with filings. It doesn't deal with inter partes communication. What we were proposing is that inter partes communication takes place within these time limits. Of course, the filing or the publication will be subject to the order of the court, and it would allow, for example, if it's done on Friday, it can be released on Friday before the end of business hours. We finish at 4. If work's been done during the day. If it hasn't been done during the day, it allows it to be disseminated first thing on Monday. But, Your Honour, if we don't even get the material before Monday, it's going to mean probably Tuesday or Wednesday if there's a dispute before, and the witness may not be here then.
Fair enough. I think we've had enough on that. We will render our ruling on the matter by the end of today's proceedings.
Thank you, Your Honours. I wonder if I could not raise a related issue. It also relates to the interpretation of the 24-hour time period which the Chamber has established, and that relates to the provision by opposing counsel for documents that they intend to use for cross-examination. Now, depending on how many other delays we have today, it may be that the witness will be cross-examined on Monday. What I would like clarity on, please, Your Honours, is whether that means the disclosure by the defence should only be on Sunday morning, or whether it should be before the weekend. I wonder if Your Honours could clarify that.
I'm not sure the cross-examination will start immediately upon your resting, because it seems that if it depends on the ruling the Chamber makes as to Mr. Nderitu examining the witness, doesn't it?
It may be, but I anticipate that this issue will arise again during the course of the trial. It's going to be a long trial, and all I seek is clarity in this respect, Your Honours.
Mr. Campbell is standing up.
Your Honour, we will respect, of course, the rulings of the court, but my learned friend, of course, sent certain correspondence to the Chamber yesterday that was inter partes. The ruling, as we understand it, of the court regarding 24 hours is not to give the prosecution, before they finish their examination in chief, defence disclosure so that they can mould their testimony. Your Honour, we took the liberty of speaking to my learned friend for the victims yesterday, and he indicated that were the bench to give leave for him to ask questions, he would be in the region of 2 to 3 hours. Your Honours, if the prosecution finished today, and even that's not certain, the way things are going, it's rather things are moving a little bit slowly. But Your Honour, if the prosecution finished today, I'm prepared to give, on this occasion, disclosure today. But Your Honour, the rule is clear, it's 24 hours. And ordinarily, we say the rule must be complied with as the bench indicated. Otherwise, Your Honour, there is this real risk that we face. If one looks at the chronology, the way that examination in chief has been dealt with, starting with the first, then going back in time, there's a real risk, and every experienced practitioner knows it, and that may have disclosed itself with the vigour with which my learned friend sought defence cross-examination material yesterday, that the prosecution will not use it in the right way, but will use it to inform examination in chief, which is going to hamper the defence ability to test this case properly, and is, in our respectful submission, not the purpose that the court rendered its decision. In that regard, Your Honours, it's important that with this witness, we anticipate with the court's leave that the cross-examination may take 2 days. it'll be quite some questions. It may be shorter. But, Your Honour, the prosecution will have ample time to look at the material before any application may be made regarding the merits of any re-examination that they may wish to make. So, Your Honour, if on a case-by-case basis the prosecution say that they are hampered legitimately in relation to a particular document or a particular line of defence cross-examination, Your Honours always have the residual discretion to adjourn matters to allow the prosecution time. But, Your Honours, we say that really is very speculative, and in the real world, with experienced counsel on the other side, that will not occur. Your Honour, we've all dealt with systems, whether it's the ICTR or the ICTY, where the traditional manner has been that only when the prosecution sits down and says no further question, the binders are passed to the other side for cross-examination. Your Honour, that is the normal course. We're happy to comply with the court order, but it must be restrictively read and not a licence to the prosecution to get advanced notice in order to change their examination in chief.
But for now, for present purposes, your undertaking is, if the prosecution rests their examination in chief today, you will provide them with your documents for cross-examination.
Yes, today, Your Honour.
Why don't we leave it at that for now, so that when we get into the more troublesome waters on this matter, we will cross that bridge then.
I'm grateful.
All right. Mr. Keegan, do you...
Other than to appreciate that you remember to ask me, I have nothing else to say.
Next time, I think I'll begin with you.
Thank you, Your Honours. I regret that there is one further issue I need to raise, which has nothing to do with, well, it's not directed at my learned friends in any way, but rather at the proceedings with this witness so far. And
Mr. Steinberg, before, I did not mean to interrupt you. If you can rest for a minute. Mr. Khan raised the matter of email being copied to Chambers, inter partes email. It is the wish of Chambers that this doesn't happen. Parties should not be copying Chambers of their inter partes communications outside of the court. Inter partes communication, period, unless there's a specific request being made and those sorts of communications are relevant in some material way, relevant to the application being made or the request being made. It does not assist for us to be in the traffic, in the middle of traffic between counsel in an attempt to resolve matters.
The actual confidential version, the court has ruled that it will be given to the legal representative for the victims. If Your Honour will give me a few minutes just to go through the annexures and come back at a suitable time and make submissions on that point.
Fair enough.
Your Honour, can I just say, I think Your Honour stopped my friend for a reason, but has a redaction order been made in relation to the earlier matter that was in public session?
We will be getting that. While Mr. Khan looks at the annexes to see which could be notified, the Chamber wishes also to indicate that in light of the urgency of the matter, and pursuant to Regulation 34, the Chamber hereby shortens the deadlines for responses to this filing and requests that the parties be prepared to present any responses they may have orally in an inter partes proceedings at the end of the hearing this afternoon. Should any party consider that ex parte information is required to be submitted as part of such a response, that party is directed to submit a supplementary ex parte filing by the end of today as well. That is the Chamber's ruling. And that, of course, puts Mr. Ken under a particular pressure to indicate which of the annexes that may be withheld. Perhaps, Mr. Ken, it might be better if you did that as part of the, if you have any reason to withhold particular ex parte filings, you may do that as part of your written response.
Grateful. And Your Honours, in relation to the earlier request, it seems that with the assistance of my learned friend Ms Allegendra, that there are only 3 annexures that were classified confidential, that the prosecution were given access to. They relate to prosecution confidential incriminatory evidence. And so, Your Honours, it may be that the prosecution, we don't have a problem with the legal representative seeing it, but they were classified as incrim confidential by the OTP. So, Your Honours, it's a matter for them. In relation to Annex E, that is a PEXO extract that was served upon us by the prosecution. Likewise, we don't have any trouble with the legal representative of the victims having sight of it if the prosecution agree. And Your Honour, the same applies in relation to Annex F, which is emails between the prosecution and the defence. Again, we have no problem with my learned friend seeing it if the bench is so minded.
So, would it be the case that you have no objection to
None.
the Victims' Council
No objection.
receiving any of the annexes as well?
No problem.
Thank you.
Thank you.
If it's material, Your Honours, that have been disclosed to the defence, there's no reason why my learned friend for the victims cannot see it.
Fair enough. In that case, the Victims' Council should be given access to all the 6 annexes. That concludes the ruling on that matter.
Mr. President. Yes, Mr. President, Your Honours. I have taken note of the arguments that will be there between the defence and the prosecution this afternoon. And I have taken special note of the fact that this is supposed to be inter partes, although, of course, at this stage, we do not have any idea as to the confidential filing. I just needed a guideline as to whether we would be then entitled to sit in during the... so is it inter partes vis-a-vis the parties, or we would also be entitled to sit in, although, of course, not to effectively participate otherwise?
You will be entitled to sit in because you're getting the filings.
So the filings will be notified to us before the afternoon then?
That will have to be the case, yes. I'm
much obliged.
We can now go into private session. First, closed session to bring in the witness. Let's back up. Let's first go into private session.
Before that's done, if I can just alert my learned friend through the bench that in order to prevent a whole new filing, we will just send him now a courtesy copy of what we sent the prosecution, and so he can look at it immediately while he's doing other things.
That's very much
with
appreciated.
The annexes, I mean.
Much appreciated, Mr. Khan. A private session, court officer.